Hello, everyone, and welcome to Uncivil Law. For today's case, we're talking about video games and assets that appear in those video games and trademark rights of people that own those assets. So, video game manufacturers often want to use realistic things in their video games in order to be more realistic. And the question is whether or not they need to license those things. So, that brings us to the case of Humvee. Specifically in the issue of AM General versus Activision Blizzard. In this case, Call of Duty included the Humvee, and they didn't license it. The question is, do they have to pay for that license, or can they use it without permission? Let's get started with this. In 1983, the Department of Defense first awarded AMG a contract to build the High Mobility Multi-Purpose Wheeled Vehicle. Since then, the vehicle, which has become known as the Humvee, has become the backbone of the United States Defense tactical vehicle fleets around the world and an essential part of United States military operations. Since the early 1990s, AMG has also granted licenses to other companies to use the Humvee trademark on or in connection with a wide range of products, including toys and at least 4 video games. Call of Duty is one of the most popular and well-known video game franchises in the world, with over 130 million units sold. Humvees are depicted in 9 Call of Duty games for varying durations. In particular, whereas sometimes they appear briefly in a background or are mentioned through passing and dialogue. In other times, players ride Humvees for several minutes during a scene or level. Further, during some scenes, they can even take control of the Humvee, including by firing a turret-mounted gun. And the plaintiffs assert the defendants did not receive authorization from AMG for such uses. Okay, so we got someone who owns the Humvee and owns the Humvee trademark and owns the Humvee assets, and they said they didn't give permission, and Activision Blizzard over here just said, yoink, that's some of ours, and we'll put that in the game. So the question is, do they have to pay? And also, of course, this goes well beyond Humvee because it would go to firearms manufacturers, it would go to all kinds of manufacturers of any kind of product. So basically, do you have to pay for trademark rights of those assets? This doesn't cover copyright interests in music or anything, just trademark rights, but do you have to pay to put it in your game? All right, let's find out. In cases where a defendant's product is artistic or expressive, courts have interpreted the Lanham Act, which deals with trademark rights, narrowly in order to avoid suppressing protected speech under the First Amendment. So trademark rights have to be narrowly construed to avoid problems in the First Amendment domain, at least if it's artistic or expressive. The court has found the balance between the trademark interests and free speech interests will normally not support the application of the trademark law unless the use of the trademark has no artistic relevance to the underlying work whatsoever, or if it has some artistic relevance, unless the use of the trademark expressly misleads as to the source or content of the work. So trademark rights, the courts have generally held, do not apply to artistic works if it has artistic merit. And if it has no artistic merit, then the only problem is if there's undue confusion as to who is sponsoring it. So, you would want to avoid, especially stuff on the outside box or things that might lead to the conclusion that Humvee is officially licensing it or sponsoring it in some way. Starting at the first prong of the relevant test from a case called Rogers, defendants' use of Humvee in Call of Duty games does have artistic relevance. Featuring the actual vehicles used by actual military operations around the world in video games about simulated modern warfare surely invokes a sense of realism and lifelikeness to the player who assumes control of a military soldier and fights against computer-controlled or human-controlled opponents across a wide range of computer-generated battlefields. Upon reviewing a copy of the game, the court has explained that using of the name and logo easily meets artistic relevance requirement under the case law because it gives players a sense of particularized reality of being part of an actual elite special forces operation and served as a means to increase specified realism of game. So everyone will believe that they're special forces, even if they're not. Not 100% sure that's a plus, but it's definitely an artistic issue. So, okay. Moving to the second prong of the test, the defendant's use of Humvees in the games is not expressly misleading. As the court in Rogers recognized, a survey that documents confusion is not in and of itself necessarily dispositive. Instead, you have to look to other factors. What other factors? Well, you go to a case called Polaroid, which is extremely famous in the trademark law dealing with this. The Polaroid factors. So you look at this multi-factor test and you see what it says. So let's go apply the multi-factor Polaroid test. The first factor from Polaroid to be applied is the strength of the mark. The defendants do not challenge the strength of the mark. Instead, they contest its relevancy. So they agree the mark is strong. They just merely say that it is not particularly relevant to the video game genre. Okay? The second Polaroid factor is the degree of similarity between two marks. While both parties have a general purpose of selling their products for profit, the plaintiff's purported concept of shared purpose is far too abstract to argue reasonable confusion. So trademarks are often domain specific. And if you're in different domains, the confusion is less to non-existent. So one person is making cars, one person's making video games, perhaps not a lot of confusion in between. So put simply, the plaintiff's purpose in using its mark to sell vehicles to militaries, while the defendant's purpose is to create realistic video games, which are not exactly overlapping. The third factor is the proximity of the factors. Specifically, the vehicles and video games do not serve a similar purpose, nor do they fall within a same general class, and they're certainly not used together, so the two goods are not proximate. The fourth factor is the likelihood the prior owner will bridge the gap. Bridging the gap refers to the likelihood that the senior user to the trademark will enter the junior users to the trademarks right in the future, or consumers will perceive the senior user as likely to do so. So who has priority over the rights? In this case, it would be Humvee in this particular respect. So they're the senior owner. So would Humvee enter their domain? And plaintiff has presented no evidence it's likely to enter the video game industry, let alone that consumers would expect it. We're not really expecting Humvee to enter the video game market, no. As such, this factor tips in the other way. The fifth factor to be applied is actual confusion. Here, there's no evidence of actual confusion. As evidence of actual confusion, the plaintiff proffers a survey, which it argues found that 16% of consumers shown an actual video game from Activision were confused as to the association with Humvee with Call of Duty. So 16% of consumers apparently were confused. Less than 20% confusion regarding two companies' association is at most some confusion. Further, Rogers teaches that mark owners must accept some confusion when outweighing with the speech interest. The sixth factor is defendant's good faith in adopting its own mark. The factor considers where a defendant adopted its mark with the intention of capitalizing on the reputation and goodwill and on any confusion between the two products. For instance, the user guide statements do not affirmatively tell consumers that Activision either owns or licenses the Humvee intellectual property. All that reasonably may be said is a paragraph in minuscule type buried in the user guide. A paragraph which does not allude to, let alone mention Humvees at all, does not consult consumers much of anything. Instead, such back-end boilerplate provides no basis for confusion between two companies' products, and this tips in the defendant's favor. The seventh factor is the quality of the defendant's product. Here, neither side has presented evidence that one party's product is superior to the other party's, and so there's no problem there. Yeah, so what's better, Humvee or Call of Duty? I don't even know. I don't really even understand the question that's being asked, to be quite honest. So I'm with the court. I'm like, I don't even know what this means in this context. The eighth factor is the sophistication of buyers. One problem for the plaintiff on this point is that the purchasers of Humvees, that is, some 50 militaries around the world, including the U.S. Armed Forces, are not buying Call of Duty and vice versa. There's not a lot of competition for the same market. Probably not a lot of people who are buying Humvees are buying Call of Duty, and probably not a lot of Call of Duty people are buying Humvees. That's probably a safe conclusion, yes. There's no risk whatsoever that someone will buy the wrong product by accident out of sheer confusion about who built or distributed the product. On balance, the Polaroid factors weigh in the defendant's favor. The only Polaroid showing made by plaintiff are the strength of its mark and a less than 20% risk of confusion. As such, the plaintiff has failed to demonstrate that contested use expressly misleads as to a source or content of the work. Thus, that brings us to the end of the discussion of Humvee in the form of AM General versus Activision Blizzard. In this case, Activision Blizzard put the Humvee in its game, and they didn't pay the licensing fee. And Humvee, AMG General, would like to be paid. And the court says, no, they don't have to pay you. We went through the multi-factor test. There's no actual confusion in the marketplace. It's being done for an artistic purpose. So they don't have to pay you your trademark rights. They can just yoink it. So sorry that you're going to, lose your licensing fees, but basically they don't have to pay you, and pretty much neither anyone else who's doing a Modern Warfare game. And that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.